If an appeal is taken from an order of the lower court, if an appeal is taken from if an appeal is taken from an order of the an appeal is taken from an order of the lower court without trial on the merits, court dismissing the case without trial on the merits or terminating for as the case may be. In case of affirmance on the ground of if an appeal is taken from an order of the lower court dismissing the case without trial on the merits, if an appeal is taken, if an appeal, so this is Rule 41, Rule 40, Section 8, 40, Section 8. If an appeal is taken from an order, if an appeal is taken from an order of the lower court, if an appeal is taken from an order of the lower court without Rule 40, Section 8, if an appeal made by a lower court, if an appeal made by a lower court is taken from an order. If an appeal is taken from an order of the lower court without trial on the merits of the case, the regional trial court may affirm or reverse it as the case may be. So if an appeal is taken from an order, if an appeal is taken from an order of the lower court without trial on the merits of the case, the regional trial court may affirm or reverse it. In the case of affirmance, the regional trial court shall not dismiss it, but shall try the case as if Rule 41, Section 8. If an appeal was taken, if an appeal was taken, if an appeal was taken, is taken from an order. If an appeal is taken from an order of, if an appeal is taken from an order of the lower court, if an appeal is taken from an order of the lower court without trial on the merits, the regional trial court may affirm or reverse it as the case may be. In case of affirmance and the ground of dismissal is lack of jurisdiction over the subject matter, the regional trial court, if it has jurisdiction, thereover, shall try the case on the merits as if the case was originally filed with it. In case of reversal, the case shall be remanded to the lower court for further proceedings. So Rule 40, Section 8 is an exception to Rule 41, Section 1, wherein even if it's an appeal without prejudice, then it is still appealable. So in the case, if an appeal is taken from a lower court without trial on the merits, the regional trial court may affirm or reverse it as the case may be. In case of affirmance and the ground of reversal and the ground of dismissal is lack of jurisdiction over the subject matter, the regional trial court, if it has jurisdiction thereover, may or shall try the case on its merits as if it has been originally filed with it. In case of reversal, the case shall be remanded for further proceedings. On the other hand, if the case was tried on the merits of the case without jurisdiction on the merits, if the case was tried on the merits by the lower court without jurisdiction over the subject matter, the regional trial court shall not dismiss the case So if the case was tried on the merits of the case, if the case was tried on the merits of the case, if the case was tried on the merits of the case, if the case was tried on the merits. Oh, so Rule 41, Section 8. Rule 41, Section 8. Okay, so Rule 41, Section 8. Rule 40, Section 8 is an exception of Rule 41, Section 1, wherein an appeal or a decision, an order dismissing an action without prejudice may still be appealable. Um, an, in an appeal, if an appeal if an appeal is taken from a lower court without trial in the merits, the the trial in the merits, the lower court, the regional trial court may affirm or reverse it as the case may be. In case of affirmance and the ground of dismissal is lack of jurisdiction over the subject matter, it shall it shall try the case. The regional trial court, if it has original jurisdiction thereover, shall try the case as if the case was originally filed with it. In case of reversal, the case shall be remanded for further proceedings. In the case, if the case was tried on the merits by a lower court without jurisdiction over the subject matter, the regional trial court on appeal shall not dismiss the case, but decide the case in accordance with the preceding paragraph, without prejudice to the amended pleading, without prejudice to the amended admissions and pleadings, without prejudice to the admission of amended pleadings and additional evidence, without prejudice to the admissions and the amended pleadings and additional evidence in the interest of justice. Okay. The period of appeal shall be interrupted by a timely motion for new trial or reconsideration. So there is the fresh period rule. Fresh period rule. Tama. State the four requisite requests present the applicant's affidavit for writ of preliminary attachment. State the four requisite. First is that it is one of the case. It shall be granted only when it appears by the applicant of the personally knows. So this is section 3. Section 3. The period of appeal shall be interrupted by a timely motion for new. The appeal shall be taken within 15 days from the notice of judgment or final order by the appellant. Where a record and appeal is required, the appeal shall be taken within 15 days from the filing of the notice of appeal, and record on appeal from notice of judgment or final order shall file a notice of appeal and record and appeal within 30 days from notice. Rule 41, Section 3. So, a notice of appeal shall be taken. The appeal shall be taken in an appeal. In appeals by notice of appeal, if an appeal shall be taken within 15 days from notice of the judgment or final order. Section 3. there's no other sufficient security so to be enforced by the order of the law should be cut with the value of property possession. Property possession thereof is possession of which is intended to recover is as much as the sum of the is as much as the sum Baste is to subserve their rights. Section. Section. dismissal of an appeal for failure of the record on appeal. Failure of the record on appeal to show in its face that the appeal was taken within the period fixed by the rules. Failure to file the notice of appeal or record an appeal within the period prescribed by the rules. Unauthorized alterations, additions, or omissions on the approved record and appeal. Failure of the appellant to take necessary steps for the completion or correction of the record on appeal. Failure of the appellant to file and serve the required number of copies of his brief or memorandum, and then absence of specific assignment of errors on the appellant's brief or the page references to the record, and then failure to pay the docket fees or other lawful fees, failure of the appellant to appear in the preliminary conference, and the fact that the final order or judgment is unappealable. Section 1, Rule 40. 41, Section 1. Within the time. Okay. There's area, it is when a third person, it is a remedy of a third person to file a petition or affidavit. It's an affidavit. If the property attaches claim by any person other than the party against whom attachment have been issued as agent, and such person makes an affidavit of his title. Third person makes an affidavit of his title thereto or right to the possession thereof. Affidavit to title thereto or right to the possession thereof. Title or right to the possession thereof, stating the grounds of such title or right, and serve such affidavit upon the sheriff, which, while the later has possession of the attached property. This is what? 57, Section 14. If the property attaches claim by any person other than the party against whom attachment had been issued or his agent, and such person makes an affidavit of his title thereto or right to the possession thereof, stating the grounds of such right to the title, and serve such Right of tertiary, it is a remedy. It's right of tertiary is the right. Right of tertiary is the act of third party of submitting an affidavit enforcing, stating his right to his right or title to the property which was attached. So right to the his title to or right to the possession of a property which was so the right of tertiary is the act of a third party to submit an affidavit to serve an affidavit to the sheriff and to the attaching party um, stating his or her right to the title of the attached. Okay, so the right of the serve, it's the right or the act of a third person who claims right of third person to submit an affidavit stating his right or he stating his right over stating his right to get the title to or stating his right affidavit of his makes an affidavit submits an affidavit of his title or right to the possession of a property that is attached that is attached in the possession of a sheriff. The affidavit is served to the sheriff, and the affidavit is served to the sheriff and to the attaching party. In this case, the sheriff is not bound, is no longer bound to attach or keep the said property, otherwise he shall be liable for damages unless the attaching party pays an indemnity bond, files. So he will be liable for damages unless the plaintiff or the um, unless the plaintiff in whose favor the attachment is ordered has been issued, in whose favor unless the plaintiff in whose favor the writ of attachment has been issued. Writ of attachment files what we call an indemnity bond. Indemnity bond. It is a bond. The purpose of which is to indemnify the third person or the third party who claims an interest in the said property attached. In this case, the court shall later on, in case the court shall later on judge that he is really entitled to the possession of the said, to indemnify the third party who claims an interest. The purpose of which is to indemnify the third party who claims interest to the property in case later on the judge in case the court shall later on judge that the property is in fact that he is really entitled to possession of said property. So that is the right of tertiary. What are the cases originally filed before the Supreme Court? This is 56 section 1. Original cases is review and certiorari quarto mandamus prohibition and habeas corpus administrative disciplinary proceedings. Discipline court habeas corpus. So that is petitions for certiorari, mandamus, quo warranto, prohibition, certiorari, prohibition, mandamus, quo warranto, habeas corpus, disciplinary proceedings against members of the judiciary or lawyers and attorneys, and cases affecting ambassadors and other public ministers and consuls may be filed originally in the Supreme Court. So what are the cases filed originally before the Supreme Court? So these are petitions for certiorari, mandamus, prohibition, quo warranto, habeas corpus, disciplinary proceedings against members of judiciary and attorneys, and cases affecting ambassadors, public ministries, and other consuls, other public ministers and consuls. State 5 grounds of discharge of attachment. The fifth. This is Rule 57, Section 12 and 13. 12 and 13. So there, the bond is first. The attachment is insufficient. The bond is excessive. These are just five grounds of discharge of attachment. So there's no cash deposit. Property attached is exempt from exemption. Rule 57, Section 13. Discharge of attachment and other grounds. The party who properly cash deposit improperly or issued or endorsed. instances of the discharge of a preliminary attachment. First is if the movement makes a cash deposit, movement files a cash deposit, the movement files a counter bond equal to the amount of the equal to the amount fixed by court in the order equal to the amount fixed by court. Here's if the move file makes a cash deposit, if the movement files a counter deposit equal to the amount fixed by court on the order on the order on the order on the order in the order in the order in the order of attachment of specific costs. The order has been improperly or irregularly issued or enforced. Improperly or irregularly, the order that the writ was if the order was improperly or irregularly enforced or issued or enforced, the bond is insufficient. The bond is insufficient. The attachment is insufficient. The bond is excessive. The bond is insufficient. The attachment is insufficient. If the attachment is excessive, the bond is insufficient, and that the property attached is exempt under Rule 39, Rule 39. This is Rule 39. So the 5 grounds of discharge of an attachment. First, if the movement makes a cash deposit, if the movement files a counter bond equal to the amount fixed by the court in the order of attachment, that the attachment was irregularly or improperly enforced or issued, the bond is insufficient, the attachment is excessive, and that the property attached is exempt under Rule 39. Improperly, or regularly. What are the modes of appeal? 42, Section 2. That is ordinary petition. Petition by appeal by writ of error. Petition for review. Appeal by certiorari. This one is 41 and 44. This one is 42. This one is 45. Ordinary appeal is RTC to CA. This one is an OG. This one is RTC to CA. This one is appellate jurisdiction. This one is RTC, CAs, and even bayan, quasi-judicial to C. This one is Fuji. The issues is questions of law. Okay. Ordinary appeal to the Court of Appeals in cases decided by the regional court in the exercise of its original jurisdiction shall be taken by filing a notice of appeal with the court which rendered the judgment, final order appealed from, and no record of appeal shall be required except in special proceedings and other cases of multiple or separate appeals with the law, special or multiple or separate appeals with the law of the issues. In such cases, the recording appeal shall be filed in separate manner. Petition for review is appeal to the Court of Appeals. Appeal to the Court of Appeals in cases. Appeal to the Court of Appeals in appeal to the Court of Appeals in cases by the regional trial court in the exercise of its appellate jurisdiction. Appeal decision where only questions of law are involved shall be the Supreme Court. Where is an appeal? Where is an appeal from the MTC taken to the RTC? An appeal from a judgment or final order of a municipal trial court may be taken to the regional trial court exercising jurisdiction over the area to which the regional trial court, so it should be regional trial court exercising to which the firm pertains. The title of the case shall remain as it was in the court. The title of this case shall remain as it was in the court of origin, but the party appealing the case shall be further referred to as the appellant and others was the appellee. If it involves pure question of law, this is SC. Pure question of fact. What is an appeal by writ of error? What issues are raised in this rule? Is it questions of law, fact? Yes. This questions of fact or mixed. So this is RTC to CA in its appellate jurisdiction. So this is law. Yeah, this is an ordinary, which is an appeal. They have questions of fact or mixed questions of fact, but never on pure question of law. Appeal by writ of error, that is petition for review. This one is appeal by writ of error. This is which an appeal to in the case of exercise of its original jurisdiction. What are the parts of the notice of appeal? Final judgment, parties, material dates. The notice of the partition shall get the parties to the appeal, the judgment of final order, and state the material dates showing the timeliness of appeal. The notice of appeal shall indicate, so that's Rule 40. Section 3. The appeal is taken by filing a notice of appeal with the court to tender the judgment. Or part thereof, and state the material dates showing the timeliness of the appeal. What are the parts of the notice of appeal? The parts of the notice of appeal. Acknowledgement and order. Thereof material dates showing the timeliness. Discuss the doctrine of residual jurisdiction, either case 41 section 9. Before the transmittal of the record, the original record or the record on appeal, the court quo or the court or the lower court may issue orders for the protection, may issue orders for the protection and preservation of the rights of the parties which do not involve any matter litigated by the appeal, by the appeal, issue, approve, permit, and then order execution. So that is issue orders for the protection and preservation, approve compromises, permit appeals of indigent execution pending appeal in accordance with the section 2 of Rule 39, and allow withdrawal of the appeal. So that is 1, 2, 3, 4, 5. So before, discuss the doctrine of residual jurisdiction. So before the transmittal of the original record, the record and appeal, prior to the transmittal of the original record or record and appeal to the appellate court, the lower court may issue orders for the preservation of the rights, may issue orders for the protection and preservation of the rights of the parties involving rights of the parties which do not involve matters litigated by the appeal, should not involve any matter litigated by the appeal. Okay, so doctrine of residual jurisdiction. Prior to the transmittal of the original record or record and appeal to the appellate court, the lower court may issue orders for the protection and preservation of the rights of the parties which do not involve any matter litigated by the appeal, approve compromises, approve compromises, permit appeals by indigent litigants, permit appeals of indigent litigants, order, allow withdrawal of appeal, and order execution pending approval in accordance with section 2 of Rule 39. Section 2 of Rule 39. Okay. So that is Rule 41, Section 9. So prior to the transmittal of the original record or the record and appeal, prior to the prior to the transmittal of of the approved record in appeal or the original record or record in appeal to the appellant court, the lower court may issue orders for the preservation and protection of rights of the parties which do not involve any matter litigated with appeal, approve compromises, permit appeals of indigent litigants, order execution pending appeal pursuant to Rule 39, and allow withdrawal of appeal. Withdrawal of the appeal. Okay, next. What are the 6 grounds upon which attachment may issue? Section 1. 6 grounds. So 1, execution of money or property. Money or property. Tapos, depart. This is depart. Property embezzled or fraudulently. Number 3, property guilty of fraud on obligations of debt. Number 4, 5, the property, oh my goodness, the property, this is to the party, this is to the, okay, money, property, so this is money or property, this should be money, this one is here, should be here, this one is to the party, this one should be money, on fraudulently or fraudulently appropriated to self, something like that. Property embezzled and different obligation. The party, oh my goodness, to self in section 1.